Hi everybody, this is Kevin. I'm in IERO 190G at UC Berkeley. The course title is Smartphone Patent War, and this week's topic is on Barnes & Nobles. So the article that I'm doing this week is from a website called ARS Technica. It's basically a technology, law, and policy website, and with news in those topics. And the article is titled "The Three Patents Microsoft is Hammering the Nook With and Why They May Be Invalid." So this article is basically talking about how this month Microsoft is basically suing Barnes & Nobles because of they potentially infringed on three Microsoft patents. The three patents are well, they're based off the fact that the Barnes & Nobles recently came out with the Nook, which is their own tablet. It started as an e-reader, but basically the Nook has evolved into a smart tablet, and it's based off the Android operating system. So the three patents are: first, Microsoft has claimed that the Nook infringes on the patent that allows making annotations in read-only documents. So Microsoft had a patent that they filed in 1999, and it basically is the technology that lets you make comments or annotations in a document that is read-only. And so, a lot of documents that you read on the Nook, a lot of the ebooks, they're read-only, but you're allowed to make notes on them, and Microsoft claims that this is an infringement. Secondly, the second patent is the technology that lets you highlight and select elements of electronic documents. So this basically means you have a block of text, and Microsoft filed a patent in 2001 that basically is a technology that lets you highlight a certain piece of this text, and you can specify how much you want to highlight. You can drag your mouse and really choose, you want to highlight these two lines or these couple words. You can really specify with Microsoft's technology. And Microsoft claims that the Nook also infringes on this. The third patent is the ability to quickly download documents from a browser. So this basically means you're on the internet and you're downloading a document, and this technology will basically look at the document, see what it can download, see what pieces of the document it can download first and fastest, and it'll download those first so that you, the user, will be able to see the content as fast as possible. And Microsoft claims that the browser on the Nook, which is based off of Android, is infringing on this patent. So, so I think there are basically three main takeaways, at least for me, from this article. First is that Microsoft seems to be more powerful than I thought before in terms of patents. They not only have patents that have to do with communication and very smartphone-related software, but they also have patents that are defensible even in this e-reader space. Two of the patents that I mentioned today are actually, all three of the patents have to do with documents and text. And that's what the Nook was originally all about: documents, text, reading, e-books, things like that. So Microsoft even has patents that were filed way back in the 90s that are still very applicable even today when we have things like e-readers. Secondly, the second point is I feel like Barnes & Nobles doesn't have much to leverage in a kind of conflict like this because they didn't develop any technology on their own. They basically have a relationship with Google that lets them use Android operating system within their tablets, and because they didn't develop any patents of their own, they can't really go in this kind of conflict and claim that they developed their own intellectual property, because they didn't. So they're really in a sticky situation here. And the third point, I think, is this could deter other non-tech companies from producing their own tablets. So Barnes & Nobles is a non-tech company; it's a retailer, but because it's a retailer and didn't come up with all this technology, intellectual property, it could be very hard for them to successfully keep making Nooks because of this patent lawsuit with Microsoft, and this could disincentivize or discourage other non-tech companies, other retailers, from producing their own tablets. So those are my 3 points. Those are this is the article I read. Have a good week, and keep reading smartphone patent stuff.